My name is Michael Young, and I'm a lawyer who handles contested estates in Texas. In this video, I want to talk about a situation with an omitted heir, an heir who is not provided for. Now, I'm not talking about the situation when there is a will and when the testator disinherits an heir, which they're allowed to do under Texas law, and the remedy for that is for the disinherited heir to file a will contest to attempt to challenge the will, and I've discussed that in numerous other videos. Now, the situation I want to discuss here is when the testator dies without a valid will. In that case, the testator's assets would pass according to Texas law of intestacy, which is Texas law provides who receives someone's assets when they pass away without a will. And that's called an intestacy proceeding, and someone can file an heirship determination. They can tell the court who they believe the heirs are, and the court will appoint what's called an attorney ad litem to perform an investigation and report to the court who they believe the heirs are, and the court will issue a determination of who the legal heirs are, and then the assets of the estate will pass according to Texas law. But sometimes I see a situation in which somebody doesn't list an heir, and it can be unintentional or it could be intentional. And here's a scenario that's not uncommon. A man gets married, has children in the marriage, and potentially had another child, even maybe before the marriage or even during the marriage, and that child born outside of the marriage just isn't recognized. That person is still a child and an heir under the law, but the applicant, potentially the surviving spouse or one of the children of the marriage, just doesn't want to list them, doesn't believe that they are legitimate, does not believe that they should inherit. Is that right? No, it's wrong. And if it's done intentionally, it's fraudulent. But what's the remedy for the intentionally omitted heir or even unintentionally omitted? Well, first of all, they can attack a judgment of the probate court and say, no, judge, the judgment you issued is wrong, and I'm an heir, and here's my proof. Usually would be a birth certificate, potentially a DNA test. Well, how long do you have? Well, typically you have 30 days to file an appeal of a judgment in Texas, but the Texas Estates Code provides a specific provision for this situation, and it's to correct a judgment of an heir. Now, this applies when the heir is not properly served with notice of the heirship proceeding. They haven't been given formal notice that this proceeding has gone on, and they have not been given an opportunity to show up and object at the time. In that situation, Texas law provides that they have 4 years from the date of the heirship judgment to object. And they would file what's called a bill of review. They would hire a lawyer. They would file a bill of review asking the court to correct the judgment and with appropriate proof. And if done within 4 years, the court will correct the judgment and will issue a determination that that heir should get their share of the assets as determined by Texas law. Now, once again, this is not unlimited. This is up to 4 years when the omitted heir was not served with the application. I'll often get calls that says, well, I was at a family picnic and they told me that my real father died 25 years ago and he was worth $20 million. That isn't going to do any good. But if you're in a situation in which there was an heirship determination that you later found out about and it's within 4 years, give me a call.